but also something that we don't often, speak too much about or hear much about, and that is on judicial ethics. So a couple of housekeeping matters, just to note, each presenter will have 20 minutes for their presentation. At the end of the 4 presentations, we will have around 15 to 20 minutes, hopefully, for discussion. You may type any question that you may have for the presenters using either the Q&A or the chat features, which are located at the bottom of your screen. And we will then direct those questions to the presenters. So that's how we will proceed. At this point in time, I'd like to invite our first presenter to the virtual podium, and that is Mrs. Jacqueline Samuels Brown, Queen's Counsel. And I am proud to say that she too, like the Chief Justice and like myself, we are all proud graduates of the UWI Law faculty. So Mrs. Samuels Brown QC is in active practice in Jamaica, and she has appeared as counsel in other Caribbean courts as well as in the Judicial Committee of the Privy Council. She's the founding member of the Advocates Association of Jamaica. She is a former chair of the Council of Legal Education and former president of the Jamaican Bar Association. She's currently a commissioner on the Regional Judicial and Legal Services Commission. And I'm sure you'll all agree that she's therefore well poised to present on the topic, training for the best while preparing for the worst, where she will explore, amongst other things, the nexus between legal education and an ethical legal profession. Mrs. Samuels Brown, the virtual floor is yours.
Thank you very much, Dean.
You're welcome.
And I would like to say how honored I am to have been invited to present at this very significant symposium celebrating the 50th anniversary, not just of the Faculty of Law, but of the establishment of the Council of Legal Education. And of course, I must, and I am happy to recognize the Honorable Chief Justice, the other honorable judges who will be presenting and or participating, yourself as Dean, faculty members of the University of the West Indies Law School, fellow presenters and participants. As you indicated, my presentation today is headed Training to be the Best while Preparing for the Worst. And I think it is appropriate that I start with the reference to the treaty establishing the law schools, the Council of Legal Education rather, and the program of training for persons who reside or wish to be trained in the jurisdiction to become lawyers. And I think it's appropriate, therefore, to start with the concept behind the treaty establishing the Council of Legal Education, which, as the slide I have put up shows, was for the development of a scheme of legal professional training suited to the needs of the, it says Caribbean, but I have adjusted it to region, and I'll tell you why, with the objectives of providing teaching in legal skills and techniques, as well as to pay due regard to the impact of law as an instrument of orderly social economic change. And I will pause here because although we have used the phrase the Caribbean in the treaty, when you read the treaty itself and see who are the signatories thereto, you will observe that it goes beyond the Caribbean. For example, we tend to think of Guyana as a part of the Caribbean, and we integrate and regard ourselves in that way. But there's a different sea around Guyana. While we examine and endorse the aims and objectives of this treaty, it need not be said that this was to be and is in accordance with the highest international standards. Endemic to this concept is a unified approach to teaching and learning throughout the region, while respecting the independence of the signatory states and the fact that there existed and would continue to exist legislative and case law variations from one territory to another. As a result, those tasked with developing and administering the curricula of the University of the West Indies Faculty of Law and the law schools have had to ensure that this fundamental principle, as well as the diversity, is embedded in the courses that we offer. And if I may be presumptuous, I would certainly invite participants to consider the comments of our Honorable Chief Justice of Jamaica in terms of expanding the curricula of the law, probably the law faculty, or making available more specialized training, for example, for members of the judiciary. But as I will demonstrate, the program that currently exists, particularly at the University of West Indies, is a very comprehensive one, and a large body of different subjects are covered in that curriculum. Happily, there is little or no discord among our citizens and those who govern us in relation to the fundamental constitutional rights, which are mirrored in international treaties, such as the European Convention on Human Rights. So too, internationally acknowledged ethical responsibilities of practicing lawyers are constant throughout the jurisdictions and mirror those of the International Bar Association. Indeed, and I made reference to this earlier, the comprehensive programs offered by the University of the West Indies and the law schools, and from the slide which is up there, you'll see that there are several programs offered by the University of the West Indies, over 50 courses in fact. And I have also put up on the screen the programs offered by the law schools under the administration of the Council of Legal Education. So you can see how comprehensive and extensive these are. So the programs are comprehensive and extensive. But the other side, and they are designed to provide training to equip lawyers for the best practices and outcomes for their clients. The other side of the same coin is that the programs are designed to prepare our graduates for the worst, for attacks by disgruntled clients, misunderstandings by the public at large as to the role of lawyers, maintenance of courtesy to colleagues despite the adversarial system of the common law, tradition, and respect for the court, while diligently and doggedly applying and developing the law. And I made reference to the comprehensive program offered at the Faculty of Law, for example, and the students, of course, are able to select and choose from the courses which are offered. So they don't have to do all the courses, but there are some key courses which they must participate in. The programs offered through both the law school and the University of the West Indies are rooted in the concept, as you can see, of the right to fundamental justice by all our citizens, while promoting and upholding the rule of law, economic and social stability and growth. Fundamental to ethical practice is knowledge of the law. And so sometimes we look at ethical practices in isolation. But we need to understand that fundamental to ethical practices is knowledge of the law, and that is why the comprehensiveness of the programs are to be taken into account. But when you leave the faculty and when you leave the law school, it is recognized by your tutors and trainers that your education is not, and your training is not complete. It means that the mentorship program, which has been endorsed and accepted by the law schools, I'm sorry, right, is a key part of the training of lawyers, because there is so much more to learn as you practice in the field of law. In fact, it's interesting to note when I revisited the programs offered by the Faculty of Law, that there are courses now offered which were not on the curricula while I was a law student. And that is because the faculty recognizes that it must keep abreast of social and economic developments and even technical developments so that the students are well prepared. Now, because of the high standards required of lawyers, because lawyers are in fact representatives and ambassadors of the rule of law, the rights of citizens, and because there often arises real and perceived conflicts or dissonance between these obligations, whenever there is any report of lawyers' misbehavior, whether a mere assertion or based on substantive evidence, it excites the public interest. This is often troubling and disturbing for lawyers, but we must take some comfort from the fact that were it not for the high expectations of most of our graduates, and that we have cultivated, these derelictions would not make breaking news. So today, I want to invite you to revisit or visit with me some of the rules, the ethical rules, of course, built on comprehensive knowledge of the law, and the application of these rules I will apply to actual cases in order to attempt to provide for you practical examples of how lawyers work for the best outcomes for their clients while they prepare for the worst. And we may just want to review the IBA rules. There are 9 of them that I have put up on the screen. And in addition to that, I want you to consider the rules, the ethical rules in your various jurisdictions. I have put up some of them. Those are incorporated in the laws of Jamaica, but I'm sure they are existing in the other jurisdictions. And although they are separate, you will see from the case studies I will invite you to revisit that they are interconnected. The first point I want to emphasize is the importance of lawyers knowing the law. And there is a case, I think, that originates from Trinidad and Tobago, which went to the Privy Council, the case of Mackenzie against the Queen, which is reported at 2011 UKPC at page 40, number 41. And it's a case in which the citizen who was convicted sought to say that the lawyer had not given him professional advice. And the lawyer was vindicated because he was able to show that he had in fact provided the advice and acted in accordance with his duties as lawyers. There are other cases that have gone to the Privy Council or the appellate jurisdiction, the appellate courts in several jurisdictions, where it has been shown that lawyers were in breach. They didn't advise their clients as to the witnesses that they could call to give evidence for their defense. And appeals in those cases have been successful. But what I want to concentrate on today, for the most part, are the cases in which lawyers are vindicated, because often that does not take center stage in the public media or in the public consideration. Now, it is the duty of the lawyer, as I indicated before, to offer sound advice based on knowledge. But a dilemma often arises where the advice is offered but not accepted, and the client is adamant that his or her instructions must be followed. What does the lawyer then do? Does he terminate the retainer? Does he convey to the other side or to the court the position he has found himself in? Does he slavishly proceed on the client's instructions? And an interesting case I found on this point, again, originates out of the United Kingdom. It is the case of Vernon and Bostley, where in one piece of litigation, the lawyer relied on evidence from a psychiatrist, which indicated he was suffering greatly. But there was another piece of litigation in which it suited the client to say that he had recovered from his psychological, psychiatric illnesses. And this was not revealed to the court. And that became the subject of one of the grounds of the appeal, which went before the Court of Appeal in that jurisdiction. And interestingly enough, the three judges who presided expressed different views on the subject as to what the lawyer should do. And that to me emphasizes the conundrum in which lawyers find themselves. There is another case which I could bring to your attention from this region, where the lawyer was not representing the particular citizen. In fact, the citizen was on the other side. And the lawyer raised preliminary points to say that the complaint he had made to a particular division of the ministry was not properly made because that division of the ministry had no jurisdiction. The tribunal ruled against the lawyer initially, but later at the end of the presentation, the lawyer was successful. The arguments were accepted. And the citizen made a complaint to the General Legal Counsel to say the lawyer was dishonest because, having said that the particular body, the ministry, did not have jurisdiction, the lawyer ought not to have proceeded to make further submissions. And remember now, this was not the lawyer's client. It went before the General Legal Counsel. This was in Jamaica. The lawyer had to spend time and effort defending this groundless claim. And in fact, there are consequences for the lawyer afterwards because it had gone abroad that the lawyer had been brought before the General Legal Counsel. And as a result, a very large statutory body, which had previously indicated that it would retain the lawyer, then said it would not retain the lawyer because that complaint stuck in the statutory body's mind. There is a case which I don't think I will get time to go into in detail, but it emphasizes that there are certain kinds of litigation which engender a lot of hostility and which means that you have to be very careful. They include cases which are born out of political differences, charges, for example, for terrorism, or which cases arise out of family conflicts, husband and wife, who gets custody of the children. And so you have to be very careful when you embark on representing clients in these cases. I invite you to visit the case of the Queen against Faruqi, which is an English 2013 cases. And I know I do not have much time, but it's very, very interesting because this was a criticism of the lawyer by the appellate court. The court noted that the defense counsel, there were 4 defendants and he represented 1, encouraged the jury to regard the judge as a salesman of worthless goods. He depicted the judge and the crown as agents of a repressive state and as being guilty of racism and seeking to stop free speech. and they accused other counsel of sucking up to the Crown and the court. This formed the basis of a substantial appeal. And so, in cases like these, you may wish to ask yourselves the question, and I will put them up on the screen: how much zeal is too much passion? And the questions are there. You can consider them as I move on to my other case study, which is based on the Canon 4, which says you must act in the best interest of the client, represented honestly and competently within the bounds of the law. And related to this is the requirement that you keep proper records, because clients who are dissatisfied with the result, who begin to feel the consequences of a loss, will then make a complaint to the relevant disciplinary body to say you did not represent them well. And unless you can go to your records and find them, then you can get in much problems. There was a case in which a police officer was demoted, and he then retained the services of an attorney to bring judicial review proceedings on his behalf. The attorney told him, "You have no case, I've reviewed it," and gave him back, in fact, his fees, and gave him a copy of the file and said, "You can go and get independent advice." And he did nothing for 7 years until he became a pensioner. And seeing, I suspect, how low the pension was at the reduced level, he then made a complaint to the General Legal Counsel. And again, if the lawyer had not kept good records, you have to consider what would have happened. The lawyer was vindicated, but again, after much time and effort. So the questions that arise here: should the lawyer have proceeded despite their own view? The lawyer could have earned more fees, but would that be in keeping with the canons of the profession? Now, I understand that I am out of time, so I will not go into much to more details of some of the other case studies I have. I understand that there will be a journal presented later, and perhaps I can expand there. But it is important to note that even among the educated and the informed, there is frequently a difficulty in understanding that there is no conflict between the provisions of Canon 1 and Canons 3 and 4. That is your duty to the client, your duty to the court to uphold the dignity of the profession. And so recently, or not so recently, in a letter to the editor of the Jamaica Gleaner, which was elevated to the level of letter of the day, so it got center stage, and a lawyer wrote, and it was headed "Defense Attorneys or Advocates of Justice, or for Justice." And in his letter, he noted, "Attorneys who defend anyone and everyone, as long as they can pay, must shut up about justice because they are party to the injustice themselves. If you are an attorney and you see it necessary, every chance you get, to lament about injustice against victims, then you should undertake on those cases that you feel the accused person or people are being unjustly prosecuted." And then he went on, "Based on the stance of defense attorneys, it would seem as though justice means acquittal of their clients, the rapists and murderers, not because they believe they are actually innocent, but because it's their job to defend them for profit. So what about justice for the victims? Aren't they more deserving of this abstract and seemingly elusive commodity?" Of course, what he has omitted there is the fact that, in fact, the victims are often well represented. And we are in what we all know as lawyers is referred to as the adversarial system. Of course, the focus of this contributor to the press and to the public debate was on the criminal jurisdiction. But similar comments have been made about lawyers in general, about civil practitioners, those who specialize in family law, commercial litigators, and labor law specialists, and particularly lawyers who represent giants in the industry against what is regarded as a small man. But we must not shy away from the fact that we are the preservers of good governance, even though we have to often walk between a rock and the hard place. In fact, the quote on the screen from William Shakespeare, "First, let's kill all the lawyers," is often misunderstood because that phrase was a phrase used by some persons who wanted to stage a uprising, and they recognized that the lawyers had to be got rid of because they were the standard bearers of good governance and the rule of law. So, in conclusion, it is a delicate balance and sometimes a difficult one that we walk as lawyers, a very fine line. However, that is the road that we undertook to travel in entering this noble profession, with professional comity, attention to detail, maintaining proper records, keeping abreast of the law. We arm ourselves with the wisdom, with the knowledge, and the understanding to better serve our clients, protect and defend our constitutions, and to contribute to a robust democracy. I thank you for your attention, and I look forward to any questions or comments you may have at the end of this session. Thank you very much.
Thank you very much, Mrs. Samuels Brown, for that very refreshing approach. The legal profession, as you pointed out, is one that's often maligned, and in many instances, the public perception is misconceived. So thanks for highlighting those instances where lawyers have been unfairly accused of unethical behavior, and also for underscoring the importance of legal education in producing ethical lawyers. So I look forward to taking up this discussion in the Q&A later on in the session. So thank you, Mrs. Samuels Brown. And having looked at lawyers who behave well, which is the majority, of course, unfortunately, there are a few quote unquote bad apples. And the next speaker will bring our attention to some of these. And this is Mrs. Daniela Gentles Silvera, who is a partner in the law firm Livingston, Alexander and Levy. But Mrs. Gentles Silvera is also the chairman of the disciplinary committee of the General Legal Counsel, where she has to deal with matters involving professional misconduct for lawyers who are in breach of the canons of legal ethics. So I now invite Mrs. Silvera, who is well poised to explore those instances of lawyers behaving badly. And her paper is on the topic, Reflections on Ethical Breaches by Attorneys. Mrs. Silvera.
Thank you, Dr. Ali. The Honorable Chief Justice, Judges of Appeal, Dean of the Faculty of Law, my fellow presenters, and all others on this platform, good morning. My paper today is, in my paper today, I have looked at some of the more interesting cases that have come before the disciplinary committee involving allegations of professional misconduct. Now, the legal profession in Jamaica is governed primarily by the Legal Profession Act, and complaints against attorneys for professional misconduct are heard and determined by a committee called a disciplinary committee, the members of whom are appointed by the General Legal Counsel. Complaints against attorneys are made under Section 12 of the Legal Profession Act, which provides that any person alleging himself aggrieved of an act of professional misconduct may apply to the committee to require the attorney to answer the allegations contained in an affidavit concerning acts committed by attorney, that is to say, any misconduct in any professional respect, including conduct which in pursuance of rules made by the counsel under this part is to be treated as misconduct in a professional respect, and B, any such criminal offense as may for the purposes of this provision be prescribed in the rules made by the council under this part. Upon hearing a complaint and making a finding of professional misconduct, the disciplinary committee may make one or more of the following orders. They may strike the name of attorney off the roll, suspend the attorney from practice, impose a fine on the attorney, reprimand the attorney, order the attorney to make restitution, order the attorney to attend prescribed course of training in order to meet the requirements of the continuing legal professional development, and order the attorney to pay cost. Now, some of the canons which are commonly relied on by complainants in support of their allegations of professional misconduct of attorneys are Canon 1B, which provides that an attorney shall at all times maintain the honor and dignity of the profession and shall abstain from behavior which may tend to discredit the profession of which he is a member. Canon 4F, that the fees that the attorney should have charged is not fair and reasonable. The attorney has withdrawn from the employment of the client without taking reasonable steps to avoid foreseeable prejudice. The attorney has withdrawn from the employment of a client without refunding fees paid. The attorney has not dealt with the client's business with all due expedition and has not provided the client with information as to progress of the client's business with due expedition. And certainly this is definitely seen in nearly all complaints that in the performance of their duties, the attorney has acted with inexcusable or deplorable negligence or neglect. And the attorney shall not account to the client for all monies in his hand when reasonably required to do so. Recently, we've been noticing a number of complaints being filed pertaining to cyber crimes committed against attorneys, resulting in loss to the clients. Criminals are hacking into law firms, lawyers' email servers to intercept and send false emails to clients, usually to change bank details. Monies are stolen as a consequence of this interception. It is known as email modification fraud. On hearing these matters, the issues which a disciplinary committee has had to grapple with is whether or not the attorney is guilty of professional misconduct. Who is responsible? The fact is that in all of these cases that we have seen, both parties are generally innocent, but someone has to pay. And the question is who? A case that has been heard and determined by the disciplinary committee, a couple from the USA retained an attorney in Jamaica to purchase real estate on the North Coast. The couple wired to the attorney's bank account the deposit payable on the sale on the purchase price, which was $30,000 US. The sale was canceled and the purchasers requested that the attorney send them back the deposit that was paid. They instructed their attorney to refund the money, to wire the money to their bank account at Merrill Lynch in the USA. These instructions were sent by email. Throughout the transaction, both the attorney and the clients corresponded by email. The email address of the female client was grace2@aol.com, and her husband's email address was john1964@msn.com. The attorney subsequently received an email from the female client purportedly changing her instructions and instead asking the attorney to transfer the money to another US bank, Bank of America, instead of Merrill Lynch, in the name of a third party, Jane Doe, whom the client advised was the couple's attorney in the USA. The attorney complied with the change of instructions and wired the funds to the Bank of America to Jane Doe. A couple of days later, the client emailed the attorney inquiring as to why she had not yet wired the funds to them. The attorney advised that she had sent it to Bank of America to the attorney. They immediately contacted the attorney by telephone and told her they had no account at Bank of America and had no attorney called Jane Doe, and further that they did not send the email. The attorney was perplexed and forwarded the email she received with the change of instructions to the client, who then pointed out to her that the email address was not correct. The email containing the change in instruction came from grace2@gmail.com, whereas the female client's email instructions was grace2@aol.com. Notwithstanding that the attorney had been communicated with the female client for the last few months at grace2@aol.com, she did not realize that the email address which changed the instructions was not the one she had been communicating with. It appears that her email had been hacked. The client obviously demanded that the attorney return the money to them. The attorney refused to do so. She contended that she was not responsible to pay the money to the clients, as it had either been stolen by third parties, or she said the clients themselves were fraudsters, or the loss was not due to the client, was due to the client's negligence, in that they probably didn't have the requisite internet security on their computers. Whatever the reasons, she said she was not responsible. The clients filed a complaint with the disciplinary committee, and they alleged that the attorney had acted with inexcusable or deplorable negligence, and that the attorney had failed to account to them for the monies in her hand. They contended that the attorney was negligent in not appreciating that the email address was not, which changed the instruction, was not the address she had been communicating with, and that she had sent their monies to a third party, and they had now lost their monies. In assessing whether or not the attorney was guilty of inexcusable or deplorable negligence, the disciplinary committee relied on the Court of Appeal decision in Whitto against Roy Forbes. In that case, Judge of Appeal Carey noted that in promulgating the canons, the General Legal Counsel had taken a practical approach, no doubt appreciating that where an attorney conducted a busy practice, some slips would inevitably occur that could be labeled as negligence or neglect, but as this was the expected consequence of a busy practice, the attorney ought not to be penalized for same as having committed professional misconduct. The proper remedy would be to seek redress by way of an action in court for negligence, and not to penalize the attorney for an act of professional misconduct. Nevertheless, according to Justice Carey, there was a level of neglect or negligence which no reasonable competent attorney would be expected to commit, and this is what Canon 4S addressed as being professional misconduct by attaching the label inexcusable or deplorable. Justice Carey noted that it was for the disciplinary committee to determine whether the attorney had gone beyond an acceptable level of negligence or neglect into the realm of what is inexcusable or deplorable. He also pointed out that a single act of negligence in the course of a matter would not normally be regarded as inexcusable or deplorable negligence. This was a difficult case for the disciplinary committee. It was actually one of the first cases that came before us in which both the attorney and the clients had suffered as a consequence of cybercrime. At first blush, one may ask the question why a more cautious approach was not taken by the attorney when she received the change in instructions to pay the monies to a different bank and to a third party. The disciplinary committee ultimately found that the actions of the attorney in not realizing the change in instructions had come from a different email and then wiring the funds to the fraudsters did not rise to the level of inexcusable or deplorable negligence or neglect. The reasons for this decision was that it was felt that in a busy practice, it was possible that the attorney would not have appreciated the change in the email address from grace2@aol.com to grace2@gmail.com. The email addresses were very similar. The attorney's evidence which was accepted was that she pressed reply to the email, which was part of a thread and had the same subject matter. She also said her firm had virus and/or malware protection, and the computers were updated daily and fully monitored by an independent third party, and the firm had a private server that was password protected. It therefore seemed that the attorney did try to protect herself and her firm from computer hacking. Further, although cybercrime is not new, it is a relatively new issue which legal profession is now facing. The fraud in this case actually happened in 2017, although the matter was not completed or not heard until 2019, 2020. So the committee gave the attorney the benefit of the doubt that the change in instructions would not necessarily have raised a red flag. Although the disciplinary committee found that the attorney was not guilty of inexcusable and deplorable negligence, we did find that she was guilty of professional misconduct in that she had failed to account to her client for the deposit. An attorney becomes a trustee of monies held for his or her client and owes a fiduciary duty to ensure that money held for a client is safe and is returned to the client. If the attorney loses the client's money through fraud of another, they are still obliged to repay that money to the client. The fact is that this case is no different because it took place over the internet than a case where, for example, a bank teller had stolen money out of an attorney's account which belonged to a client. In such a case, the attorney will be liable to account for that money to the client and thereafter seek to recover from the bank. It is difficult with these internet fraudsters to try and recover. So we felt that the attorney was actually guilty of professional misconduct. We ordered the attorney to make restitution to the clients in the sum of 30,000 US together with interest. Now, in the United Kingdom, the falsifying of emails makes up 80% of cybercrimes reported to the Solicitors Regulation Authorities in the second quarter of 2018. According to the Solicitors Regulatory Authority, in the first half of 2020, approximately £2.5 million held by law firms were stolen by cybercriminals. Email modification fraud has become one of the most common types of cybercrimes affecting the profession, but there are also others on the rise, such as ransomware and phishing. These cybercrimes have resulted in law firms and lawyers suffering loss in the form of stress, delayed transactions, pressures on lawyers, staff, and clients, high insurance premiums, having to pay out financial losses, such as in the case that came before the disciplinary committee, damage to client relationship, and lost jobs. Lawyers, given what has happened, need to be more mindful when receiving and acting on instructions by email, particularly as it relates to the payment of money. More careful and additional steps should be taken to confirm instructions pertaining to the payment of money and bank details, such as getting confirmation by letters and telephone. It is also perhaps time, especially in Jamaica, for lawyers to begin considering insurance for this type of fraud. They have set out on this slide here some of the steps which, based on my research, I have seen that is being recommended that lawyers take to protect their firms or their offices from cyber attack. Use firewalls to secure your internet connection, protect all your devices with antivirus software, recognize computer scams, create secure passwords, avoid changing payment details or making payments without thorough checks, avoid downloading unsafe applications or browsing on unsafe sites, avoid opening email attachments without knowing who or where they are from, encrypt mobile devices and install a system that can wipe them if they are lost, periodically test your processes and carry out assessments to check for vulnerabilities, train your staff to better recognize suspicious emails and keep devices secure, keep your software updated, and scrutinize the sender's email address by right-clicking on the sender's name or hovering over it. One of the other canons that are commonly relied on by complainants that come before the disciplinary committee are failure to account. There was a complaint that came before us where an attorney had failed to account to the client for purchase price, for proceeds of sale of property. The attorney did not pay over the full amount to the client, notwithstanding that the client demanded it. When the attorney appeared before the disciplinary committee, he didn't deny that he had not paid over the proceeds. He candidly admitted that he had taken the client's money for his own personal purposes, but told us that he intended to repay the money out of money he was to inherit from his father's estate. By the time the matter came up for hearing, he had actually paid back most of the money which he had taken from the client. The disciplinary committee found that the attorney had misappropriated the monies belonging to the client who had placed all trust and confidence in him, in retaining him to protect their interest in the sale of the purchase of the property and allowing him to collect the purchase price. And he was therefore struck off the roll of attorneys. He had betrayed the trust and confidence and deprived his clients of the money and placed a stain on the reputation of the attorneys in general. The panel relied on the case of Bolton versus the Law Society, where the Principles that we have gleaned from that case is that an attorney who has breached his professional duty with anything less than complete integrity, probity, and trustworthiness must expect severe sanction. The other principle to be gleaned is that most serious lapses involve professional dishonesty, in which case, no matter how strong the mitigation advanced, the tribunal will still order the attorney to be struck off. As was said by the learned master of the rolls in this case, the reasons for such an order is both punitive, which is to punish the attorney and deter him from future behavior, but it is also to maintain the reputation of the attorneys and sustain public confidence in the integrity of the profession. This judgment by Sir Thomas Bingham in Bolton and the Law Society has been repeated and relied on in our Court of Appeal and in several cases, including Georgette Scott against the General Legal Counsel, where the Court of Appeal upheld the disciplinary committee's decision to strike the name of the role of a lawyer off the roll of attorney. Another interesting case which arises out of the complaint that the attorney had not accounted to the complainant for all its monies, and also Canon 1B, that the attorney shall at all time maintain an honor and dignity of the profession, is that of Owen Clooney against the General Legal Counsel. In that case, the claimant, who's the client, sought to purchase property. He gave the attorney money as a deposit and legal fees to down pay on the property. After doing so, he hadn't heard from the attorney for some time, and he started to get worried. He eventually discovered that the house he had wanted to buy had been sold to someone else. He got in touch with the attorney, who apologized and promised to repay him the sum, and I should say the deposit that was paid was $600,000. The attorney promised to repay him the sum of $600,000 plus $100,000 to cover expenses which the complainant had incurred. The attorney signed a repayment agreement agreeing to pay these sums by July 2012. He didn't repay the sums, and in September 2012, he signed another repayment agreement with the complainant, giving the same promise that he would repay this money by a certain time. That promise was not fulfilled, and therefore the complaint was laid. At the hearing, the attorney indicated that the facts were not in dispute, and he requested an adjournment of 4 weeks to pay back the money. The application for the adjournment was denied. The disciplinary committee found that the attorney had misappropriated the complainant's money. They struck him off the roll and ordered by way of restitution that he pay the sum of $700,000 to the complainant with interest. The attorney filed an appeal, and the Court of Appeal of Jamaica quashed the sanctions imposed and ordered that the matter be remitted to the disciplinary committee to hear submissions in mitigation. The Court of Appeal held that the committee, notwithstanding that the attorney hadn't admitted misappropriating funds, the committee should have afforded him an opportunity to address them on sanctions, as sanctions were not fixed. The matter was remitted, and the committee heard the matter again as directed by the Court of Appeal. They heard submissions in mitigation and also permitted the attorney to lead evidence. Evidence was given by two practicing attorneys, a retired judge of appeal, and a rector at a church. The attorney also gave evidence. He said he had actually made restitution to the complainant and paid him $100,000 more to compensate him for the inconvenience caused. He had been a police officer for 39 years before he retired from the force. On his retirement, he was at the rank of Deputy Commissioner of Police in charge of special projects. Since the making of the order striking him off the roll, he had not practiced, and this had adversely affected his ability to provide for his family. And also the publication of the decision and the striking off had caused him severe distress and embarrassment. He promised the committee that he would observe the canons of professional ethics more studiously, and he would zealously guard the client's funds to ensure complete accountability. The disciplinary committee relied also on Bolton versus the Law Society and struck the attorney off the roll again. They stated in their decision that the striking off order which we propose to make is not imposed with the intent of punishing the respondent, but rather to protect the public and the reputation of the profession. The respondent's conduct amounted to extreme dishonesty and there are, in our view, no exceptional or extenuating circumstances warranting the imposition of a lesser sanction. Indeed, we go further to say that the imposition of a lesser sanction would be so shocking that it would damage the reputation of the legal profession in the eyes of right-thinking persons, and it would undermine the maintenance of high standards of behavior and honesty by members of the legal profession. So regardless as to whether or not an attorney has repaid their monies wrongfully taken, the sanction, which is usually imposed by the disciplinary committee, is a striking off. Clients place a lot of trust in lawyers. They tell them their secrets and permit them to collect and hold monies on their behalf. It is expected that persons who enter the legal profession will be honest and trustworthy. When an attorney misappropriates funds belonging to his or her clients, it affects the reputation of not only the particular attorney, but the reputation of all attorneys. Such a breach is so egregious that even where he repays the money stolen, the right and proper sanction can be none other than a striking off. Now, another canon that we have been seeing a recent increase in complaints have been the canon dealing with breach of an undertaking. And that canon, I remind you, says an attorney shall not give an undertaking, a professional undertaking, which he cannot fulfill, and shall fulfill every such undertaking which he gives. In a case that came before us, Marine Wildlife Publication Limited against Jermaine Sims, Mr. Sims had given an undertaking to a firm to pay $32,500 on the 30th of September to settle the indebtedness in respect of the use and occupation of the complainant's premises at 8 Norbert Drive by the tenant Carlos Hill. The property had been leased to Cash Plus and was occupied by its principal, Carlos Hill. Payment of the rent fell into arrears, and the firm of attorneys were instructed to recover possession of the premises. They filed an action for recovery of possession, and the attorney sent a letter to the firm in which he advised, after stating that he was instructed by one, Mr. Sterling, the principal attorney for Mr. Carlos Hill, we hereby formally undertake to pay to you the sum of $32,500 on Tuesday the 30th of September 2008 in full and final settlement of Mr. Hill's indebtedness to you for rent in arrears outstanding and due and payable to you. On the 30th of September, he did not honor the undertaking. When he came before the disciplinary committee, the attorney said in his defense that in giving the undertaking, he had relied on the assurance of Ms. Sterling, who was the attorney for Mr. Carlos Hill, that he would be put in funds. So he admitted that when he gave the undertaking, he did not have the funds in hand. The disciplinary committee found that the attorney had given a clear and unambiguous professional undertaking to pay the law firm $32,500 on the 30th of September. That undertaking was a professional undertaking given by him in his capacity as an attorney. And although he had been warned by the firm's principal attorney that he should not give an undertaking if he did not have the money in hand, he still gave it and therefore was in breach of Canon 6D. The attorney was struck off the roll of attorneys and by way of restitution was ordered to pay the complainant the sum of $32,500. The panel relied in this matter on the Court of Appeal decision of Sylvester Morris against the General Legal Counsel, where the court held that where an attorney gives a professional undertaking, non-performance is not excused because the attorney relied on some other person, whether that person is a client, an employee, a partner, or an instructing attorney. Now the next canon and the final canon which I will have dealt with is that of Canon B. And that is an attorney shall at all times maintain the honor and dignity of the profession and shall abstain from behavior which may tend to discredit the profession of which he is a member. The disciplinary committee have heard complaints citing this canon where the complaint does not necessarily arise out of a lawyer-client relationship or the circumstances where the misconduct is not committed by an attorney in a professional capacity. And there are authorities which have established that misconduct in a professional respect, as referred to in Section 12 of the Legal Profession Act, is not limited to misconduct committed by an attorney in professional capacity, but it extends to conduct which is unworthy of a member of the profession or which may discredit the profession. In a recent complaint heard by the disciplinary committee, the complainant alleged that the attorney had breached her contractual obligation in relation to a bank loan that the complainant stood guarantor for. Consequently, the bank debited the complainant's account based on the terms of the guarantee. He relied on this canon. During the hearing, evidence was given that the parties had actually enjoyed an intimate relationship in the past. The attorney actually told us that she deliberately decided not to repay the money she borrowed from the bank because she knew that the complainant owed her money, and she knew that as he had guaranteed her the loan, the bank would seek to recover the money from him if she failed to pay the loan. The attorney clearly thought that because her actions with the complainant was guided by a domestic relationship that the parties shared and not an attorney-client relationship, that she had committed no act of professional misconduct. This view was misguided. The attorney entered into a legally binding contract with a third party to borrow money, and therefore was not only under a legal obligation to repay the said sums, but also a moral and ethical obligation. Her issues with the complainants were between the two of them to work out. Notwithstanding, the attorney deliberately defaulted on her contractual obligations to the bank when she had legal remedies available to her to recover the sum she alleged was due to her by the complainant. The disciplinary committee held that the conduct of the attorney must be viewed by the bank as dishonorable. Such behavior did not place the profession in a favorable light, but tended to discredit the profession. We had considered actually fining the attorney in the amount of the sum which the bank had debited the complainant's account with, but decided against it, as the complainant had, we felt, also deliberately left out a lot of details in his complaint, such as the nature of the relationship he had with the attorney. He obviously was left the complainant to conclude that there existed an attorney-client relationship. We therefore found that the attorney was guilty of professional misconduct, but what we did in that case was to issue a reprimand. Now, in conclusion, in representing a client, an attorney must take all due care with his client's business and be honest and trustworthy. As whenever an attorney fails to live up to these standards, it does not only affect the attorney, who may be subject to disciplinary actions, sanctions, but it invariably affects the profession as a whole. To borrow from Bolton against the Law Society, a profession's most valuable asset is its collective reputation and the confidence which that inspires.
Thank you so much, Mrs. Silvera, for that presentation and for reminding us all about the importance of compliance with the canons or codes of professional ethics and the dire consequences that could flow, indeed, the death penalty on one's reputation, one's career, and the reputational damage to the entire profession if one is struck off. And also for highlighting some of the new and emerging threats that we face by virtue of the increase in online transactions and online communication. So I look forward to expanding on some of these key issues that you have raised in your presentation. So thanks again, and we'll take up the discussion later on in the session.
Thank you.
So having heard a discussion on the importance of compliance with the legal professional code or canons based on the jurisdiction that you're in, it's important to also consider what sort of liability one can face in the common law. And so, one could be liable for negligence, breach of contract, breach of trust, and so on. And so to take us through this area, we have the Honorable Mr. Justice Vashis Kokaram, who also is a proud graduate of UWI Law. Justice Kokaram was appointed to the bench in 2009, and he was appointed to the Court of Appeal in 2020. He has been the Judicial Settlement Conference judge since 2009, and he's a past chair of the Mediation Board of Trinidad and Tobago. Justice Kokaram also taught ethics, rights, and obligations at the Hugh Woodin Law School, and he is currently a tutor there in civil practice and procedure. In 2018, Justice Kokaram delivered a judgment in Moraldo and O'Brien on the liability of an attorney in negligence for failing to set aside a consent order after a concluded mediation. So Justice Kokaram is going to speak to us this morning on the attorney's ethic of care, drawing new lines of responsibility. Justice Kokaram?
Thank you very much, Chair Shazida. Are you hearing me clearly?
Certainly we are.
All right, I'm going to share my screen. Computer sound, share. Are you seeing?
Yes, we are seeing your screen.
And let me take from the beginning. Right, good. Thank you very much, Shazida, again, Chief Justice, fellow panelists. Some very good, invigorating papers so far. Looking forward to Justice Dennis Morrison's paper as well. Greetings from Caribbean South, TNT. Good Saturday, all. I want to take a little twist on the law of negligence with regard to attorneys' responsibilities. And I'm going to start off with a clip from The Matrix. For those of us who know about The Matrix, let's go.
I know you're out there. I can feel you now. I know that you're afraid. You're afraid of us. You're afraid of change. I don't know the future. I didn't come here to tell you how this is going to end. I came here to tell you how it's going to begin. I'm going to hang up this phone, and then I'm going to show these people what you don't want them to see. I'm going to show them a world without you. A world without rules and controls, without borders or boundaries. A world where anything is possible.
I want to tell you about a world of collaborative lawyering, a world that no longer needs the traditional litigator, the adversary. It's a world of civil dispute resolution populated by peacemakers, collaborators, the humanist advocate, embracing fully an ethic of care. This humanist advocate is focused on the well-being of the client and treats the client's dispute by not only collaborating with the client, but collaborating with the opposing party, the opposing client, co-opting the assistance of other specialists to create peaceful solutions that are multidimensional, therapeutic, and even restorative. Your redefined relationship with your client now places you at the heart of the delivery of social justice. Now, I cannot tell you when that world will be fully formed, but I can tell you when it should begin. Richard Susskind famously theorized of tomorrow's lawyers as providing more than legal services, serving as counselors, moral supporters, financial advisors. He theorized that the future belonged to a different kind of professional. Counselors, caregivers, big picture thinkers. It's a picture of a different type of legal professional than pertains in the Caribbean adversarial system. The focus of litigation is never about the peaceful resolution of a human problem, but more about the end of a litigated dispute. But if we realize that our clients are not interested in litigation, but on practical, humane solutions for human problems and the peace, we can think and rethink not only the adversarial model of dispute resolution, but the role and function and purpose of the Caribbean attorney. Are we in a profession that destroys or heals? Should we not place a premium on the therapeutic effect on law on human activity? And if we are talking about professional responsibility, this type of introspection is necessary now, and it's probably of seismic proportions since fusion in the 1980s. Speaking of professional responsibility, Sir Fred Phillips in 2004 remarked that a combination of the worldly wise clients about their rights and the greater solicitude and vigilance showed by the government and courts to citizens suggests that the business of lawyering in the 21st century is likely to become more exacting. There are patent anomalies between the professional responsibility of the humanist advocate that the modern client demands and the one that presently exists. So, for example, the law of negligence in our relationships, which governs our relationships with clients, shapes a lawyer whose duty of care may not necessarily be linked to this ethic of care. The law may recognize that while you may be in breach of your duty of care and therefore negligent, yet your moral and professional duties may not have fallen below the standards recognized in the profession and therefore not guilty of professional misconduct. Conversely, is the law governing the professional duty and negligence constructed around the duty of care and proximity and foreseeability drive us further away from our ethic of care. The lawyer, therefore, who frames a case into the door of the adversarial world for his client, has he not already failed his client? In family disputes, for example, have we already breached our ethic of care in failing to promote and actively pursue reconciliation and collaboration? So the premise of this paper is that we are at the cusp of creating a more humane system of collaboration. If lawyers and judges alike take the lead in embracing fully an ethic of care and infuse a humanism in our gatekeeper functions to justice and peace, this will require incremental changes in the common law, and I'll focus on professional negligence and legislative intervention to create such an advocate. I'll first focus on the humanist advocate. I've previously advanced in papers that there's the changing role of the humanist judge brought on by the civil proceeding rules. But the civil proceeding rules has brought a seismic shift in roles, responsibilities, and powers of the court to shape litigation. And the concept of early court intervention reflects the role of the court to resolve matters as early as possible, but also it encourages the role of the attorney in active pre-action processes to collaborate and find just solutions. A just disposition by amicable means is the lawyer's first priority and duty. So we do have our ethical codes that we looked at in our panelists previously in the Caribbean and in Jamaica, and some of them buttress this humanistic point of view. It's in the interest, for example, where it's in the interest of your client, you'll obtain a reasonable settlement of disputes. Another code or canon would be an attorney at law shall always act in the best interest of the client. Where controversy admits of fair adjustments, a code will suggest that you will inform your client accordingly and advise to avoid or settle litigation. It's just the start of recognizing this ethic of care. And the idea that really sparked this paper was that case that Dr. Ali referred to, Moraldo and O'Brien, a claim in negligence against an attorney. And it showed the glaring divide between the traditional lawyer and the humanist lawyer. In that case, Mrs. Moraldo was involved in litigation for possession of land against her cousin. And both her cousin, that's Mr. Sandiford, and Miss Moraldo filed their own actions and cross claims for possession of land and property. These two High Court actions went through our litigation system for over 10 years, injunctions and appeals. One judge retired until that matter came onto my lap. Eventually, the parties entered into a mediation session and emerged with a mediation agreement. It was forwarded to me with the initials of the mediator and the attorneys, and the consent order prepared by them sent to be entered without further hearing. After entering the consent order, Mrs. Moraldo changed attorneys and filed two High Court actions, one against Mr. Sandiford to set aside the agreement, on the ground that she did not execute it and gave no consent, and second, against the lawyer in negligence for entering a consent order without her actual consent. Both claims were dismissed. It was determined that there were no exceptional reasons to set aside the consent order, as it was found that an agreement was made in the mediation room, even though she did not actually sign the document that came to the court. Even though Mrs. Moraldo complained she did not give authority to her lawyer to enter the consent order, this was not communicated to the court nor to the other party who acted on the authority of the representation of the attorney. Interestingly, both parties in that case waived the confidentiality of the mediation process so that evidence was adduced as to what transpired in the mediation. The mediator himself willingly participated despite the statutory bar in our Mediation Act. Also of note was that the attorney's conduct, even if negligent, was protected by both advocate and mediation immunity. That matter was referred to the disciplinary committee and is now under appeal. But it raises a fundamental question. Quite apart of the pain of litigation, what is our responsibility to our client when it comes to dispute resolution and dispute avoidance? Are we familiar with that rule? And does the law set out the markers of responsibility to create the environment to promote the development of the attorney's professional conduct to better serve the client in a humanist world? So your codes of conduct, whilst are still entrenched in the adversarial world of litigation. But to discharge your ethic of care, you must either avoid litigation altogether or transform your role in the litigation process to convert the adversarial model into a collaborative one of full and frank disclosure, acting in good faith, owing a duty to the other party to share all relevant information, all with a duty to narrowing issues for discussion and for working jointly with the court to assist both the court and both parties. It's not surprising that we in Trinidad and Tobago and perhaps the rest of the Caribbean have not yet fashioned a code of ethics to specifically deal with this aspect of dispute resolution. It was never thought about in 1986 when we first proclaimed our code, as the vision of that advocate was either in short supply, unheard of, or never encouraged. 35 years now later, I submit that our legal world, already revolutionized by the CPR, now demands a different type of advocate. Now, quite apart from the law of contract and wasted cost orders, how can the law enact this change in behaviors? How can the law of negligence usher and shape this new attorney? And so there are a few lessons we can learn from the law of negligence. First, the building block is to recognize your duties arising from relationships. As Lord Atkin famously established the neighbor principle of duty of care, what duties of care should arise from a person in your close and direct relationship? Is the failure to provide advice on humane solutions to such a person to be treated as neglect and therefore attract liability? If part of your skill and the assumption of is indeed that of a collaborator, can the law recognize your increased duty to opposing counsel and the opposing party? At present, the law protects a practice of keeping your client in his own private silo, owing no duty to assist the other. As Lord Justice Thornton said in Republic of India in 1997, a party to litigation is not obliged to be the nursemaid of his opponent. And the law presently recognizes your professional responsibility to opposing parties in limited cases, such as undertakings and the like. But for the humanist advocate in the collaborative world, the principles of trust and good faith between parties is the first and paramount concern. Maybe in such areas, that traditional duty of care owed by the humanist advocate, the law may be required to fill the gaps in liability to ensure that there's practical justice by upholding the standards of this profession. And that is where the law evolved the White and Jones principle of doing practical justice between the parties may provide the answer. What is the standard of care of the professional humanist advocate? And the law must continue to interrogate what is the attorney's professional role in the community. So in Minkin, the 2015 case, an attorney was not negligent in drafting a consent order in matrimonial proceedings without giving the client advice about shortcomings in a settlement. But for a humanist advocate, this type of reasoning that you are not responsible for the folly of your client may not be applicable and may be totally opposite to your ethic of care to counsel, to promote practical human solutions that are not short-sighted. Even more difficult is to determine what should be the best and standard practice for this profession. And that would involve a close examination of our legal training, pupillage systems, entrenched mandatory professional development courses, and better yet, the training of the bench on the world of ADR so that they can develop and maintain this standard, increased standard of care, judged by the reasonable professional, continue to be interrogated by the court along the lines of the Bolitho gloss on the Bolam test of professional responsibility. Can the law of negligence accommodate a higher standard of care of the attorney to accommodate a notion of neglect beyond simple negligence? And finally, if we did care to embrace this new world, we would easily accept the transparency and accountability that comes with the provision of this service. To this end, the elimination of advocate immunity in certain parts of the Caribbean must be lauded and must be re-examined in other parts that still hold dear advocate immunity, such as in Trinidad and Tobago and certain parts of the OECS. Indeed, this statutory embargo on actions and negligence for any actions which include the manner in which the attorney conducts litigations is part of the problem. While pre-action work, which include advice on options to settle or to craft human solutions, will be exposed to actions and negligence, so long as the work does not involve litigation, it serves no public purpose, save for creating an entrenched, divisive position of the litigation advocate, free to make decisions in a process regardless of its harmless consequences to the client. Considerations of professional misconduct apart, from the very fact that a duty of or duty to care does not exist within the walls of the court is uncaring and inhumane. So finally, to wrap up this thought, I turn to the question of what do we need to develop the world of collaborative lawyers? And it begins from Lord Atkin's recognition of the extent of your duty from a very basic, practical, and humane principle: who is your neighbor? He was concerned with a profound aspect of relationships and the human response to care for the well-being of others. So how do we encourage the professional responsibility that is now primarily results-oriented, and to regard the advocate as an expert dispute resolver in a world of collaborative lawyers? 5 quick notes. 1, there will now be the need for the law of negligence to recognize a growing field of the mediation advocate, where the lawyers play a more proactive and engaging role in the mediation session. 2nd, if we place a premium on the duty of the humanist advocate to collaborate, it unlocks a new dimension for professional response. The client is fully aware of all ADR possibilities and fully engaged in that process. Thirdly, specific codes and rules will be needed to address this ethical obligation. 4thly, further legislative intervention may be necessary, such as introducing apology acts, where attorneys can issue a formal apology to a client when a dispute arises without admission of legal liability, such as many parts of the US and Canada. And finally, to create this right environment, we may look at specialist dispute resolution processes to deal with attorneys' complaints, which are not retributive, but also restorative, rehabilitative, and therapeutic. So to conclude, I cannot say when the world of the humanist advocate and collaborative lawyers will take full flight. I can only say that it can begin now with us interrogating deeply the relationship to legal responsibility that comes with an ethic of care, the humanity that yet can be shown to an increasingly critical public wary of our legal system. While the first steps can be made by innovations in our common law or legislative interventions, the smallest step can be made by you. You hold the key for